Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics, or are your politics starting to shape your faith? In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our panelists for today. First, we have Mr. Todd McFarland, Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We have with us Mr. Tim Schultz, who's the president of the First Amendment Partnership. We have with us Mr. Andre Wong, who is the General Counsel of the North Pacific Union Conference of the Seventh-day Adventist Church. And we have with us Dr. Timothy Golden, who's a professor of philosophy at Whitman College. Gentlemen, looking forward to our conversation for today. You know, gentlemen, there seems to be an ongoing conversation as it relates to the application of Title IX exemptions for religious schools. We're finding ourselves going back and forth in courts, having a constant conversation of whether or not religious schools should be exempt, whether or not Title IX should be something that actually is aggressively implied. And we've been going back and forth. And I think a lot of the questions that people have been really trying to understand is, what is this Title IX? Why is it such a big deal? And what's the problem as it relates to religious schools? You know, there's some that believe that the founding fathers would have never imagined that this, any type of subsidy would ever go to any type of religious institution, and that maybe even a religious school gaining any type of proceeds is a violation of the Establishment Clause. You know, Tim Schultz, when you think about what's going on, and obviously you've been involved in a lot of work relating to these issues, can you help our audience to understand the concept of Title IX and actually the impact that it has as it relates to religious institutions like schools, and what could be the potential problem people may have?
Yeah, Orland, three things about Title IX. First, it's the part of our federal civil rights code that bans discrimination on the basis of sex in education, okay? Enacted by Congress, and when Congress enacted it, it also included a religious protection. It does not apply to religious institutions. Now, that was Congress's will, and Congress's will has to be respected. Of course, it's still subservient to the Constitution, and we'll discuss those issues in a second. It's really important to know Congress has ratified this twin idea of protecting people on the basis of sex discrimination, but also protecting religious institutions. The law doesn't apply to them. Okay, so second, Title IX is most famous for what it has done for women's sports. It is because of Title IX. And so if you talk to anybody involved in women's sports now in the last 30 years, most will say that the flourishing of women's sports to have sort of equal programmatic access that men have had, since sports began, really is owed to Title IX. And so Title IX, and I happen to agree with that analysis, okay? And then lastly, there have been questions about religious protections in all kinds of civil rights statutes for years and years. But the most famous case and the most applicable case is a case the United States Supreme Court decided in 1987 called Presiding Bishop of the Church of Jesus Christ of Latter-day Saints versus Amos. And in that case, the Church of Jesus Christ of Latter-day Saints applied employment standards to exclude someone from, working for them because they had violated the standards of the faith. And there was a lawsuit that alleged that the religious protection for them in the employment context was an unconstitutional breach of the separation of church and state, that it was providing a benefit to a church that that would be unconstitutional, right? A violation, it was claimed, of the Establishment Clause. Now, the lower court agreed with that argument, that protection that would apply to the Church of Jesus Christ or Seventh-day Adventists or any other church or religious organization, that was an unconstitutional religious protection. Fortunately, in 1987, a unanimous United States Supreme Court sided with the Church of Jesus Christ and by extension, every other religious organization, and said these kinds of religious protections in the law, and by implication, including Title IX, are constitutional. So That's the history, and I think that the court got that right. By the way, this was the court when it was still applying the so-called Lemon test, which the court has now pretty much abandoned. So even under that old sort of more hostile to religion Lemon test, the Supreme Court, and this included people like Thurgood Marshall and Justice Brennan, legendary progressives, applying that Lemon test found that these kinds of religious protections and statutes do not violate the Constitution. So this is an old discussion that's coming up again because there are still some people that are looking for new and creative ways to be hostile to religion.
I think one of the balancing acts and one of the real problems that we have in America, and maybe this is something sort of unique to being an American, is that we have to try to please everybody, right? We have to, as Tim so nicely articulated, the history of Title IX and the potential for problems here. We have to strike a balance between, on one hand, making public policy that advances the cause of equality for women without doing it in a way that jeopardizes equality for others in religious organizations. And the dirty little secret to being an American, I think, is that while the founders may not have anticipated this problem, they did create Congress and give Congress lawmaking power to deal with these types of issues that we see here, whether it be the House of Representatives, who the founders decided were those who were closest to the people, and those who were closest to the people, they thus had to be more accountable in regular elections, right? So there's a joke in the House that you're always running for office, right? Once every 2 years and so forth. So the public policy dimensions of the American political life are where we really find the biggest challenges. And I think, again, I've said this before, as long as we are walking a tightrope, I think we're probably getting it right. As long as there is a tension there, we're probably getting it right. If you read the First Amendment, I think there's almost an inherent antagonism between Congress protecting the free exercise of religion on one hand, and on the other hand, calling for preventing its establishment, right? That's a tension. That's a problem. And you heard Tim Schultz talk about that. So in terms of other people arguing that religious exemptions violated the Establishment Clause. So this is where we get the down and dirty of public policy and American political life. And I think as long as we are tense about it, we're probably getting it right.
But Andre, is the real issue here just a question of, women's sports and male sports and religious institutions may not have the kind of money that, the Alabamas of the world may have to be able to have 10 sports with one? I mean, is that what the real issue is we're dealing with here? Or is it something more complicated?
Well, the broad application that Title IX's exemption has taken over the past decades goes beyond constitutionally protected accommodations, and provides clear financial incentive for religious institutions. So Title IX centers on government money, and schools are required to follow Title IX if they receive federal funding and are at risk of losing the funding if they violate Title IX. Now, the religious exemption to Title IX, codified by Congress in 1988, states that religiously affiliated schools are exempt from Title IX protections that oppose their religious beliefs, regardless of whether or not they receive federal funds. So religious exemptions are common in American law, but courts have yet to rule, on this whole idea of the constitutionality of the Title IX's exemption. Now, however, that the religious exemption creates this little discussed loophole, right, that allows federally affiliated, religiously affiliated schools to legally discriminate. most notably in LGBT students, and we'll get to that. So to the point of that's been discussed. This is just a wide landscape of what's next in legal realm.
If I can, just two things. One, just a little correction. So Title IX does not apply. What the Congress changed in 1987, they fixed a case called Grove City College, which said that restricted it only to the department that received the money. So if you receive federal financial assistance, only the part that received that, in this case, a financial aid office, had to follow Title IX. Congress fixed that. If you don't take any federal funds, which some schools don't, then you're not required to follow Title IX, but that's a very small subset. I also want to make clear the very limited nature of this exemption. It only is when it conflicts with your religious beliefs. So the big areas where Title IX is enforced, which is sports and then sexual misconduct or sexual assaults or hostile environment, to the best of my knowledge, no religious organization has ever even asserted an exemption in either of those two areas. So the exemption has come in places like trans rights, same-sex couples, that kind of stuff, which I would argue when Congress passed this back in the 70s was not on their radar at all, and you couldn't have got it passed back then, right? But the courts have reinterpreted Title IX in our federal laws to include protections for that. So the religious exemption is a very, very narrow one.
In practice, that's the point, right? In practice, it's barely ever.
Yeah, it is, but it's also statutory, right? It is a limited one, and you would have, I think the reason that they haven't raised that is two. One, it would be very hard to argue that our religion compels to allow sexual harassment to go on. No faith has that in their thing. And then also the public reaction to that would be very narrow or negative. So I think it's both the statutory language and the PR impacts of that has led to a practice. And I think it also demonstrates how people say, well, a religious exemption, in other contexts, say employment will just be a license to, for discrimination. It's going to cause all this, negative consequences. And the answer is no, it won't. We see what happens with the limit exemption, both in Amos that Tim talked about, and then also the one that in here in Title IX is that it has not had a practical impact on the negative stuff that what Title IX is mostly used for.
I'm going to have to let that be the last word. But, an interesting concept is you have a lot of religious institutions that will say, well, take away all this government money. We're not getting it anyway. But when you actually drill down into the specifics of what really comes into these institutions, you realize that government funding is involved in many ways, like in Pell Grants and in student loans, the types of things that we don't always think about. But this is an argument we're probably going to see ourselves talking about much more into the future. There's an interesting case out there, which is called Hunter versus the United States Department of Education, in which you now have this going before the Ninth Circuit, who recently ruled in an attempt by some activists that wanted to prevent students from directing federal tuition assistance to educational institutions that share their religious beliefs. In this particular case, we start seeing that the Department of Education, in conjunction with other religious institutions, are having a bit of a battle. Federal law explicitly protects the freedom of religious schools to live out their deeply held convictions, and the courts are hoping to try to find the right balance between making sure that people's religious beliefs are going to be protected, but also making sure that funds are not going to an organization that either doesn't have an exemption or going to an organization that's really just proselytizing and talking about, quote unquote, and furthering religion. We start talking a little bit about Title IX and how it gets impacted as it relates to the Constitution, and seeing how now we're seeing more activist groups that are really coming out and getting involved, even when there's nothing specifically in front of them to get involved with. That seems to be the way that legal operations are going right now. When I take a look at this, Andre, and you start realizing how important this is, we would have thought that maybe this would have been handled before, but now there are questions regarding gender, sexual morality, and other issues that are coming up. The groups are saying, let me see if I can put this in this Title IX box. And if I can put this in this Title IX box, maybe I can squeeze some funding from going to certain places, because at the end of the day, no money, no mission.
Yeah, so Hunter v. Board of Education or Department of Education is really the laboratory for this. In this case, the plaintiff sued the Department of Education, challenging the religious exemption within Title IX that allows private religious schools to operate according to their beliefs on gender and sexual morality, even if this means denying admission to or services to LGBT students while still receiving financial aid, financial funding. So essentially arguing that this exemption violates the rights of LGBTQ students seeking to attend these schools. And so the argument is that this exemption allows religious colleges and universities to discriminate while also receiving federal aid. The position, as from the Department of Education as the defendant, they're defending the exemption, and so really, arguing that it's really necessary to protect the religious freedom of the institution and students, and so we see in this case several Christian colleges and universities represented by, I believe, the Council of Christian Colleges that are speaking on behalf of religious freedom in this case. And so recently the Federal Court of Appeals and Ninth Circuit dismissed the lawsuit, ruling in favor of the Department of Education. But I don't think this is the last we're going to see it. I think we're going to see this issue continue in different forms.
Yeah, I mean, this case was never about trying to change the law. That would have been, you would have had to have overruled a U.S. Supreme Court, unanimous Supreme Court decision from the 1980s with a much more friendly court to religion now than it was even back then. Plus, I don't think any of the more progressive justices would have voted to overturn Amos. There's been no indication they would want to do that. This case was about one thing and one thing only, and that was trying to embarrass religious schools and attack them in the public square. The fact that the Washington Post had this a full article written on this lawsuit on the day it was filed, that the plaintiff or that some of the schools involved found out about this in the newspaper, shows what was going on. These attorneys that were handling it were not the best and the brightest. They made some mistakes in there that they should never have made, one of which I'll talk about and something you might not know. And so the attempt here was to really it's not just to change what the schools do, but also to change their religious beliefs. So, for instance, an Adventist school was mentioned in there, where they weren't a defendant, but one of the plaintiffs went to an Adventist school. But one of the things they complained about was what was being taught in religion classes. What is part of the curriculum? So it's not just a claim, hey, I was being harassed on campus. It was, oh no, the religious nature of this school, where they disagree with the lifestyle choices or the sexual morality choices I've made, that is creating the hostile environment. So let's be very clear here. This is trying to weaponize federal law to impact religious schools and religious teachings. Unfortunately, even the liberal Ninth Circuit, even forum shopping for a very progressive judge, which they absolutely did, that was the one thing they did right from their perspective, didn't work.
As I think about this, I'm listening to Todd and I'm thinking to myself, there are consequences for advancing an argument in federal court if you're not doing so in good faith. And I'm starting to think now, if litigation is used or misused in this sort of bad faith way, solely with the aim of trying to shame or embarrass litigants, in this case, religious colleges and universities. I'm thinking about, there's a rule called Rule 11 in the Federal Rules of Criminal Procedure. And Tim, I'm curious to see what you think about this, because as I read this case, the first thing I'm thinking of is the precedent from the 1980s, the Amos case, right? Which would seem to me, if a client comes to me and they wanted to, on this fact scenario, file a lawsuit, the first thing I'm going to say is we don't have a leg to stand on, right? Because as Todd just put it, we have a Supreme Court now that is more friendly to religious institutions than it was 40 years ago. So I don't know, Tim. I mean, I think about this and I think, we have, I don't like it when courts become battlegrounds for these ideological and cultural fights, in this case, seemingly from the left, to try to just shame people, right? I don't know, Todd. I mean, I don't know, Tim. I was thinking about Rule 11 sanctions and that sort of thing. So what do you think about that?
Well, so it's interesting you say that because I was going to talk about Rule 11 too. I mean, this is a classic example of what is sometimes called vexatious litigation.
Yeah.
But I think as we've seen in other contexts, for example, the continued harassment of the Colorado cake baker, Jack Phillips, Rule 11 seems to not be applied as much as it ought to be, right? So Rule 11 seems to sort of be there in theory to deter sort of bully lawsuits. But in practice, it doesn't seem to be used really quite enough. And I think that really leads us into this discussion that I think the law on this case was just clear. It was clear to me from the time that this stupid lawsuit was filed that the Christian schools were going to win because the law is so clear, even in front of what I think is the second most progressive court of appeals in the country. But the process is the punishment, right? If you're the schools and you have to spend hundreds of thousands of dollars on legal fees, that itself is a punishment, right? Nobody enjoys this kind of controversial litigation. That is itself a punishment. And of course, that was the point of the plaintiffs. I think they knew subjectively they were going to lose, but they wanted to extract several 100 pounds of flesh from the defendants. And I just don't think that's what courts are for, not just in this context, but in any other context. So I personally think this is a great example of why we need more Rule 11. There's one other little footnote about this case that I think is also worrisome, is that in the amicus briefs that were filed on this case, 17 state attorneys general, including the Attorney General of New York, Illinois, California, sided with the plaintiffs on this cockamamie legal theory. And so maybe they did it because they felt like they had political pressure to do it. But the fact that you have 17 attorneys general taking a position that probably no member of the United States Supreme Court would take, right, and that even Justice Brennan wouldn't take in 1987, that is really worrisome. It shows you that there's still people out here with this very, very tiny, tiny view of what religious liberty is. And I think that at the end, even though all's well that ends well, in the Ninth Circuit, I think that there are some sort of troubling signs, some dark linings within this cloud.
Yeah, I will say this. I agree that this had turned into a political process. I mean, let's not forget. So only the Department of Justice was originally defendant, right? But this lawsuit was filed at the beginning of the Biden administration. There was concern how much they were going to defend it. And so a CCCU, and I forget if it was just them or if they had a school join, did intervene. The Department of Justice opposed that. They originally said, oh no, we're going to vigorously defend the religious exemption. That created all kinds of concern on the left. So they then amended their response to say, well, we'll just defend it. So I don't know what the difference between DOJ vigorously defending and just defending is, but they felt there was a difference there. And so the school's involvement, or through CCCU, Coalition for Christian Colleges and Universities, for those of you not familiar with our insider nomenclature, they intervened and I think really held DOJ's feet to the fire on this. I will say, while everyone on this panel is an attorney, I think I'm the only one who actually practices law, as in filing lawsuits and defending them. I will say, while I think they didn't have a chance, it does fall short of the Rule 11 standard, which is very, very high. And no one went for that, and I think that was wise, because there are times in which, all sides sort of swing for the fences, and Rule 11 really needs to be just, a complete failure. And even if something's unlikely to be happening with a district court or court of appeals to the Supreme Court, you should be able to take your shot if you want. But yeah, this organization, REAP, was the one behind it, the Religious Education Accountability Project. Never did find out whose money is behind that, but this was a litigation to make a point, not to make law.
So Andre, what's the happy medium here? We're trying to figure out how to balance, protecting schools, not going too far. Well, what's the happy medium here?
Well, as I mentioned at the beginning, this is really kind of the laboratory of kind of, what's to come, and this isn't the end, really. I mean, while the law is clear, I think we're in consensus with that. While the law is clear, this will continue in new shapes and new forms. While this was a political power play on the left, this isn't the end. We're gonna see it. We're gonna see this again.
And I think in the grand scheme of things, we should be seeing this again because, we move from administration to administration. We move from year to year. We have different thoughts in different parts of the country. But the idea of us being able to peacefully coexist, where you've got religious institutions that are going to be supporting their religious beliefs, but making sure we don't violate the Establishment Clause is still going to be critical. Hey, Todd, tell me something I don't know.
When the plaintiffs in the Hunter versus Department of Education we got done talking about originally sued, they attempted to sue the federal government on a statute called 1983. The unfortunate portion of for that was that statute by its term says you can only sue states under 1983. So they had to amend their lawsuit because they literally could not read the words of the statute that they sued under.
Andre, tell me something I don't know.
When Franklin Pierce was sworn in as the 14th president of the United States in 1853, he was the first president to take the oath saying, "I solemnly affirm."
Tim Golden, tell me something I don't know.
Great Frederick Douglass broke from radical abolitionist William Lloyd Garrison and decided that, in his view, the Constitution was not a document that endorsed slavery, but rather for him was a document of glorious liberty.
Wow. Tim Schultz, tell me something I don't know.
The presiding Bishop versus Amos case was decided on March 31st, 1987. Just 2 days before, on March 29th, I was watching with my friends on pay-per-view WrestleMania 3, where Hulk Hogan body slammed Andre the Giant in front of 90,000 plus fans at the Pontiac Silverdome. And I've been a Hulkamaniac ever since, brother.
Wow, I actually knew that when I saw it as well. Gentlemen, great being with you today. Really enjoyed our conversation. And thanks again for you being here today. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith in politics. See you next time. Hello, I'm Orland Johnson. I'm the host of Faith in Politics, your ultimate destination for a broad range of religious and political current events. Join me in a panel of experts as we dive into the latest religious news, dissect significant legal decisions, and navigate the complexities of politics. Stay informed, stay engaged, subscribe now.